With that being said, we will get started. I am very pleased to welcome your presenter, Tracy Glanton. She is an attorney for the law firm of Ellerbe Thompson. Started off as a police officer, I believe, within California. Is that correct?
Virginia.
In Virginia. Did you live in California for a while?
California. Not as a police officer.
Not as a police officer. Okay, that's where you went to law school. But she's going to talk to us a little bit about record retention and specifically within law enforcement. I know that's a question out there. So if you can stomp your feet and clap your hands.
GPS signal lost.
Tracy's going to mute her phone.
How does that happen?
Janice Price asked, and again, within these webinars, we like to see as much interactivity as possible. Janice Price asks, I am muted. How do I become unmuted? Well, Janice, I have to find you on the list here, and I have to physically unmute you. And the reason we do that is because in order to prevent a bunch of different noise going on. But I'm going to unmute you. Janice Price, are you out there?
Yes, Dan. Thank you.
Oh, you're welcome. Any questions you want to ask before we start? Okay. Very good. Just let me know, and we will. Here we go. Moultrie is here. Janice Price is here. McDonough. We got all kinds of things here. So, Tracy, go ahead and kick it off.
All right. Well, good afternoon. Thanks for having me. Thanks for carving an hour out of your afternoon to talk about records retention. Might not be as sexy a topic as some others, but it's a necessary one. And just by indication of the number of people who signed up for the webinar, it seems to be a topic of interest. And so hopefully I can answer your questions. And if I can direct you to some resources where you can get the answers you're looking for. So records retention is important for a number of reasons, okay? There's a modern trend towards electronic communications and the use of electronically stored information. When I think about my day and what I do, there's very little time when I'm working when I'm not using some form of technology, whether it is a cell phone, text messaging, social media, the internet, email, laptop, computer, and so on and so forth. And I know that that's the same for you all. As technology develops, we start implementing more and more technology into our business. And so the question becomes, what is the best way to retain that information? Because legally, as a government agency, you are required to retain certain records. And so we're going to talk today about just generally what those legal requirements are, and then how to or what to consider in terms of putting into place, if you don't already have one or if you need to update one, a records management policy. So with that, we'll go to the next slide. I think we're on the same page, yeah. So we'll talk about some of the key state and federal retention requirements. There are some consequences for non-compliance that we'll also discuss, and we'll talk about some steps that will help you in terms of crafting a policy if you don't already have one, or reviewing and updating a records management policy that may already be in place. So what are the benefits of record retention? Okay, there are a number that are listed here. Obviously, first and foremost is to meet the requirements of state and federal regulations and law. Another, again, we'll talk about in more detail as we move along through the presentation, but how do we avoid undesirable consequences of non-compliance? How can we use our records management system to effectively support investigations and litigation? Now, I know there are probably some of you that are working on antiquated systems, and you probably understand the burden I refer to when you find yourself involved in either a very comprehensive open records request or litigation where you have to start now investigating where certain documents are that are being requested, and then pulling all of those together. And if they're not at your fingertips, or you don't know where they are and you don't know who has those records, it can be extremely time consuming for you and for your staff. So that's one of the reasons, at least from the lawyer standpoint, is to help you understand the records you have and how to retain those and how to effectively obtain them when requested. Open records, you have 3 business days to provide records. And so if you can access those records, you're required under law to provide those within 3 days. Now, there are some workarounds for that, but that is just one reason why it's important to be able to retrieve your records efficiently. If you have a record retention practice and policy in place and you're actually following it, it can provide continuity in the event of a disaster. If you have backup records and certain records are lost, if you have flooding, or something like that happens, or you have, something happens to your electronic system and you lose data, hopefully you either have records in hard copy or backup. And so in the event you do lose some information, hopefully that information is still available. And it also maintains agency memory, or just historically how your government agency has operated. So those are just a couple benefits of having a record retention program. So what we're going to talk about for a minute is the Georgia Records Act. You can find this, if you feel inclined to, at OCGA 501890, and that basically sets out what the requirements are under Georgia law in terms of your responsibilities for record retention. The entity that oversees record retention for local governments is the Division of Archives and History at the University System of Georgia. Now, some of you may recall, if you've been around for a little bit, that used to be in the hands of the Secretary of State, and that has since transitioned to UGA from 2013 forward. So their responsibility really is to establish and administer records management programs, particularly for local governments. They help develop the procedures relating to records management, and then they're also there, this is important, to assist you with implementing your records retention programs. And I'll give you a link to their website later on in the presentation that you'll have. But if you ever have questions about records retention, they are a great resource, and we've contacted them, and they've always been very helpful in terms of giving us guidance. And when we had questions about record retention and things of that nature. So you'll have that resource, and I encourage you, if you have questions, to visit the website because it's very informative. But they're available to consult with you. They'll help you do surveys and audits. Before you have a records retention program, or if you already have one in place, you should frequently audit it to make sure that it covers the kind of records you have. But before you can even have a records retention program, you've got to understand what kind of records you're creating and maintaining. So that would require going through and doing a survey or an audit of your particular government agency and figuring out what you have, because if you don't know what you have, you don't know how long to retain it. And then they also do provide training, and they operate the Records Center, which is a center that houses government records. So there are certain times when maybe your government would transfer records to them for storage. So they would oversee that. So under the Georgia Records Act, specifically as it relates to local governments, on the next slide, wink, wink. Yeah, we're on the right page now. 501899 of the Georgia Code sets out record retention requirements for local government, okay? And so what it tells you to do is that you have to approve via resolution or ordinance a records management plan. And resolution or ordinance, as most of you know, is the equivalent of a law. So once you have that in place, it is a legal obligation. So you're required under law to have a records management program that is approved through your governing body through either resolution or ordinance. So a couple things that you want to look for in your records management program is the person who's going to be responsible, right? It's all well and good to have a program in place, but if you don't have somebody who's responsible for making sure that your policies are updated and that they're being implemented properly, then you're going to fall short of meeting your legal requirements. And so in your policy, you want to identify either the name or title of the person responsible for compliance with your record management plan. And I would recommend not using somebody's name just because, you know, there are transitions in positions. And so what I would recommend is to have the title of the position that's responsible for your records management plan. And if somebody transitions out, for example, if you have a city clerk who's your custodian of records and who is also going to be the person responsible for your records management plan, make sure that when that person leaves and that position transfers to another, that that person knows that they are responsible for your record management plan. So your program should also include the schedule that's approved by your governing body, whether it be your city council or your board of commissioners. And so we'll talk about some of the record retention guidelines that are provided by the by UGA as part of the records retention program, and those are minimal, or the minimum recommended retention period. And we're not going to go through every single record because that wouldn't benefit anybody. But like I said at the beginning, I'm going to give you the website, and you can go there, and we'll talk about some of the records that I pulled and I thought were interesting. But if you have questions about it, it's certainly not comprehensive, is my point. So if you have questions that aren't covered today in terms of, you know, well, how long am I supposed to keep this record, and we don't talk about it, you'll be able to go to that website and search for it. And then also make sure that you have provisions for maintenance and security of records. You know, how are the records going to be retained? Are you going to retain paper copies? Are you going to retain electronic copies of paper originals? How are you going to retain video feeds or audio recordings, emails? So all of those things need to be decided while you're drafting or implementing your records management program. Where are those records going to be stored? Are they going to be stored on site? Are you going to have third-party storage? Are you going to have virtual storage? And so those are also questions that you're going to have to ask yourself and figure out what works best for your agency.
So Tracy, do we have, or do you know of how we could come into access to having a model program or policy like this? Is there something that exists that people might be able to adopt?
Just offhand?
Yeah.
You know what, Dan, I'm not exactly sure. Where I would go to look for that would be on the website.
Okay.
And so I'm not sure. I thought maybe at one point they had a model program there, but I'm not sure if that's still there.
Okay.
So you're not supposed to ask questions,
sorry,
right?
Typically I don't ask questions that I don't know the answer to. I did not know the answer to that question.
So anyway, look, I don't know everything, right? Believe it or not, no. And so look, if I can't answer your question, I will certainly go back and try to find an answer for you. And if I can't find the answer, I'll find someone that can.
And again, I think, Tracy, what I will do based on that answer is probably we'll start researching to identify a model program, something we can provide to our membership. So I'm sure out of the 165 people that are signed up to attend this course, I'm sure one or two would like to see some type of model program.
Mm-hmm. Yeah, and it would be good to have, something is sort of to start from it anyway, and work from that, because your agencies are probably going to be a little bit particular, and so there may be some tweaks. But yeah, so let us know if you find that, Dan.
I will do that.
And another thing in terms of, security of your records, I mean, you guys have heard of these ransomware attacks. I can tell you from the law firm perspective, we have been just dumping a lot of money into technology over the last number of years, because we know how critical it is to protect the information that we have in our system. A lot of that information comes from you if we're representing you in litigation, and we have, other clients that have, proprietary information and trade secrets and things like that. So it's really important for our firm and for you as the government to make sure that the information that you have is secure and protected from any of those attacks. And, that takes someone who's very knowledgeable in IT that can direct you and your agency in terms of the best programs to put in place to make sure that your records are secure. And you all have, I mean, I know some of you do electronic applications. You guys have medical information electronically. And so all of that, if it's not protected, that is subject to any of these attacks and theft of personal information of not only your employees, but of citizens as well. So security is extremely important, and it's something that I would encourage you to focus your attention on if you haven't already. So what are public records, right? What needs to be retained under Georgia law? So basically, anything that you create in the furtherance of your public duty, okay? The definition says all records created or received in the performance of a public duty or paid for by public funds. So, other than a simple email, hey, you want to meet for lunch at noon, things like that. If it's in furtherance of your job, it is going to be considered a public record. So it's going to be subject to retention requirements, and it's also going to be subject to Open Records Act requests. So basically, we're talking about everything that you create in the performance of your job. It also includes records that are prepared and maintained or received by a private person or entity in the performance of a service or function for or on behalf of an agency. So if any of you have hired or worked with private companies to provide government services, for example, maybe you have a private company that's operating your water distribution system, or maybe you have a private company that is providing code enforcement services for your agency, or maybe you have a private company that's doing your payroll. All of those records that they are creating in the performance of the government services on your behalf are all considered public records. And so it's critical that when you are entering into agreements with these third parties, that you understand and that they understand what the requirements, what the retention requirements are for particular documents that they are creating on your behalf, and making sure that those are not lost and destroyed. And then also it includes records when the documents have been transferred to a private person or entity by an agency for storage or future government use. And so, people always say, well, hey, look, if we enter, this comes up, hey, if we enter into a quote unquote confidential settlement agreement and we just give it to you, it's not subject to open records, right? Well, no. As probably most of you know, that even if you call it a confidential settlement agreement, it's still a public record subject to open records. And just because you give it to your lawyer doesn't mean that it's not subject to open records or retention requirements. So anything that is, you cannot shirk your duties by shoving off your documents to a third party. All right, so retention schedules, this is where I mentioned before the the email where you can go if you have questions about certain documents in the retention period for a particular kind of document. So if you go to the Georgia Archives website at the address I gave you and kind of search around there, you'll see the retention schedule. And it has all sorts of categories. And then when you click on the category, it'll give you all sorts of subcategories with the recommended retention period. I would say that most local governments adopt the state recommended records retention requirements. And so you can always decide if you want to retain them longer, just not shorter. These retention schedules, they're reviewed every 2 years and they're updated accordingly. And you'll see if you go to the website, you'll see sort of the last time that it was a particular requirement or guideline was updated. Also consider statutory retention periods. In other words, there might be a specific statute or regulation that has specific retention requirements for certain kinds of documents. So for example, on the next slide, one of the provisions in the Georgia Records Act applies to law enforcement. The videos from body-worn devices or devices located on or inside law enforcement vehicles, okay? And so I think probably most law enforcement agencies these days use one form or the other or both. And so, you know, the question is, especially with the in the vehicles, sometimes you've got those cameras that are just running, you know, for hours on end. Sometimes they're activated, you know, at certain points. But that could result in a lot of footage. And so, you know, what do you need to keep? How long? Because it can get very expensive when you need a certain amount of memory to store, especially audio and video. So under the Georgia Records Act, you're required to retain those kind of videos for 180 days from the date of the recording, okay? Unless, right, it's part of a criminal investigation, it shows a vehicle accident, it shows the arrest or detention of an individual, or it shows the use of force. And in those instances, you're required to retain those videos for at least 30 months. And so you could round it up and have a 3-year retention period for those. But, you know, how do you determine? I mean, you don't want to keep all of that footage. So, you know, you're going to want to address some of these retention requirements. Hopefully, if you're using those devices, you've also got policies in place which guide their use. But one thing you also want to do is include retention periods in there and make sure that somebody is at least reviewing that information to make sure that, you know, the things that need to be kept longer than 180 days or 6 months are tagged and retained and not inadvertently deleted. So
a couple questions. One, I got a question here from Shelley Frost. She asked, can we get a copy of this slide, show us to refer back to? And I'm going to say yes. So anybody that signed up for the class, I will send the presentation along with a video of the presentation back to everybody. But my question goes to basically this point. So what you're saying is, let's say you have a video that is 4 hours long. They had a body camera, but only a half hour of it, or let's say 15 minutes of that video shows an accident, vehicle accident, or arrest, or use of force. They'd only need to, they could cut out everything else and use that 15 minutes or so before and after and keep that. They wouldn't need to have to keep the whole thing. Okay.
Correct. Yeah, I mean, otherwise it kind of defeats the purpose, and then it, you know, you end up in a situation where you've got, you know, huge voluminous storage requirements and costs. So, which is why it is important to designate somebody to make sure that they're reviewing those videos and tagging those things that need to be kept for longer than 180 days. And so, you know, you need to make sure too that you just don't have a feed that records over itself too, because you've got a requirement to retain those videos from the data recording for 180 days. And so if you've got a dash cam video that just kind of records over itself, that's problematic, at least under the Records Act, because you're required to keep all of that footage for 180 days at a minimum. And then if you've got a recording that has evidence that is or can reasonably be anticipated to be necessary for pending litigation, then you retain that for 30 months or until final adjudication. So most times you are going to know, unless an investigation lasts for years, which in some cases maybe they do. But once you're on notice that you know, there's been an arrest or a lawsuit's filed, whether it's civil or criminal, you need to make sure that that information is tagged and retained beyond the 30 months until final adjudication of the litigation. And that includes any appeal period as well, which is usually 30 days after final judgment in either a state or federal district court. And again, these are just the minimum periods that are recommended. You can always decide if you find that you do an audit of your records and there's all of, they're kind of all over the place. These are 180 days, these are 2 years, these are 3 years, these are 6 years. Maybe you find a time frame, for ease of retention that's encompasses all of that. It just depends. So you're going to have to figure out what's best for your agency. Also, this is interesting too, which is specifically in this code section we're talking about, there is no requirement of redaction. So, there are times when, for example, officers wearing the body cams are going to enter into private residences. And they may obviously, inside somebody's residence, that is a private place, although as long as the law enforcement officer is legally allowed to be in that location, they are allowed to record, and there is no requirement that those videos be redacted. Now, I say that, but I also say that under open records, you may have a request for certain body cam footage. And you may decide in consultation with your city or county attorney that depending on what the content of that video is, and if there are certain privacy concerns, that you may want to redact those portions of the video before providing them in open records. So that's going to be, there's no requirement to redact under the Georgia Records Act, but there may be some privacy concerns that you may need to be addressed if those records are being produced in response to an open records request. All right. So this is just, something to think about on the body camera and dash cam policies. I also, on the slide before, I also put drones. And while drones is not specifically listed in the statute, it is listed on the archive website along with, the body cams and the dash cams as being subject to these same retention requirements. So if you've got, and you should if you're using them, body camera and dash cam policies, again, make sure to incorporate into your policy the retention requirements. That way everybody knows and is on the same page about how long certain records, videos need to be retained. Set time periods for regular review of the videos. Make sure that you have someone designated to obtain the videos and to review them and to do whatever deletion is allowed under law, and then whatever tagging needs to be done to make sure that certain records are not destroyed. Define the procedure for tagging videos that are subject to retention, and then define the procedure for retaining them and then deleting the records. So it's really important in your records retention program to discuss how records are going to be deleted, because as we'll talk about later, there are certain consequences that can arise if you are found to have destroyed certain records that are subject to retention requirements, or that are destroyed after you're on notice of pending litigation. And one of the sort of argument for deleting things is, well, we did it in accordance with our records retention program. And if you're just kind of randomly deleting certain records, and you get in litigation down the road and you're found to have deleted certain relevant records and you did it not in accordance with a policy, what's going to be the argument? The argument's going to be, well, clearly there was something in that record that was adverse to the agency, and so they deleted it to avoid having to produce it in litigation. And so that is why it's so critical to have the process for deleting records and to follow it, even more importantly, when you're going to destroy records, so that if something is destroyed, that later turns out to be relevant to litigation and you destroyed it in accordance with your records program. And I'm saying the caveat being you're not on notice of pending litigation, because once you are, those records need to be retained. But you can say, look, we did it in accordance. Here's our program. Here are the requirements under law that we passed via ordinance or resolution, and these were deleted in accordance with those. And then you won't get an adverse inference, which we'll talk about in a little bit about what that means.
So Tracy, two questions. One, do you have any policies on body cameras and dash cams? Anything that, and the answer, I have an answer. Yes, we do. LGRMS does. So if people need those, you can request those from LGRMS. We can give you sample policies on those. So if, let's say you're involved in litigation and you have a dash cam or a body camera footage of an incident, and whether it's whatever it shows on the camera, that evidence or that camera footage is deleted, what happens to the litigation at that point in time?
In other words, if there was dash cam video, say for example, maybe of an accident or an arrest or something like that.
Yeah, let's say it's a use of force dash cam or a use of force body camera.
Okay, and it's deleted before.
They somewhat accidentally, it gets deleted. How does that affect the litigation against the city and or organization?
Yeah, I mean, a lot of that's really going to depend. I mean, clearly Georgia law requires you to retain those documents for at least, or those records for at least 30 days, right? And so if it's a use of force incident, chances are, I'm going to guess that more often than not, there's an arrest involved, right? So there's going to be some type of pending criminal proceeding. And so those documents or those records need to be retained in the course. Now, you're going to be sort of on notice right away that there's going to be pending litigation, probably more likely than not, some type of criminal case. And if you get into court and you don't have those, and it come to find out that you recorded them and you inadvertently deleted them, you can get what's called an adverse inference from the court. And basically what that means is we get to instruct the jury that there was something negative on that video in it. I mean, that puts the question in the jury about what was actually on that video. And so it can work, I mean, depending on what the adverse inference is, I mean, that might completely wipe out a defense that you might have.
Here's a question from, can you verify the time frame in producing documents for an open record request?
Yeah, generally it's 3 business days. Unless for some reason you cannot gather the documents in those 3 days, or if it's a voluminous request, there are other ways to go about addressing that. But if you can gather the information within 3 days, you're required to produce it in 3 business days.
So Arlene, hopefully that answers your question. If not, ask again. Thank you for the question.
Which is why, again, it's so important to be able to, know what records you have, know where they're retained, so that when you do get an open records request, you can go to that location and you can access those records efficiently.
And Arlene says, thank you.
So the retention periods on the next slide that are the recommended retention periods and they're not just recommended when you implement your program, they're required. They apply to all records regardless of format. So really when you're looking at something, it's not, well, how long do emails need to be retained? It's, well, what is the content of the email? And that's how you determine the length of time that the email needs to be retained. And so, you know, one of the things that people are always surprised about are voicemails, because what happens? You get the voicemail, you listen to it, you delete it. And, you know, 9 times out of 10, it's not going to be, it might, you know, it's probably not going to be something. It's going to be what's considered a transitory record, and it's not going to be sort of a, what I consider a business transaction or in furtherance of the business. But if there is voicemail that does contain information or content that would be considered a public record, those have to be retained. And so, you know, how do you, some of you, again, might be working on systems where the voicemails are not retained electronically. So we have a system in our office, which I think is called Voice over Internet Protocol or something like that, where when somebody leaves me a voicemail, I get a notification through my Outlook email, and it's actually saved as an electronic file. So I can file that voicemail wherever it needs to be filed. And so if you don't have a system like that, again, we'll talk about training and why it's important to your employees to retain or to be able to identify which records need to be retained, what are public records, and then how to retain those. Same thing with text messages, right? I mean, most people have cell phones now that are smartphones that are provided by the employer. And, you know, we've all been through this. Somebody gets terminated, they turn in their phone, and guess what? Oh, the screen's broken. Guess what? Everything has been deleted, and it's all back to default. And so we have lost everything. And so, you know, one of the things that you may want to consider when you're talking about your records retention policy, you know, that, again, that audit I'm talking about, okay, well, we've got, you know, we've issued, you know, cell phones and smartphones to our employees, and they're using them for business. And so those are public records. And so maybe you want to consider putting something in place to do backups of those periodically to make sure that all of that information is not lost if something bad happens or somebody wipes out the information before turning the phone in upon separation. Social media, anything that is done in the course of business that's on social media, that would be considered a public record. Recordings that we talked about. So again, it's not the type of record that dictates the retention period, but what's really contained in the record that's subject to the retention period. So
give me an example of a voicemail that people would need to separate.
Okay, so for example, what if I email or leave you a message and I provide you legal advice in a voicemail, right? Okay. That would be considered, I mean, that would be considered a public record, although there are certain provisions in place that would prevent that from disclosure. But, you know, something along those lines where there is, you know, if it's just like, hey, meet me over, you know, at the rec center at 12, I don't know that that would be.
But let's say that I, as LGRMS or a representative of LGRMS, provided a recommendation to and did that via a text or did that via a voicemail, then that would be considered a public record.
I think so. Okay. Yeah, I mean, the definition is really broad.
Okay.
And so if it's anything that's done, I would say in the performance of the business, the government, then I would say that that's a public record. And I would err on the side of caution.
Okay.
But it's a lot broader, I think, than what most of us think about. I mean, we're thinking about like a paper personnel file, right?
Yeah.
So now we need to start thinking about, you know, all of the electronic devices that we're using and creating a record of our business. We talked about agency history, right, and memory. I mean, all of that, those transactions now are taking place electronically and might not be through letters and written correspondence, paper correspondence. Okay. So
if let's say that we have a phone conversation and you take handwritten notes of that conversation, then that's a public record,
That
right?
would be a public record.
Okay.
Yeah.
But if you don't take notes, you just keep everything via memory, then that's not. Okay.
Well, I don't know how you retain your memory. All right. That's what we struggle with. I don't know.
I have a photographic memory
Yeah.
for almost 14 minutes every day.
Well, trust me, I'm not saying that there are times when you don't want to make written notes of things, but I'm just saying. But yes, if they're written and they're in the course of business, then yes, they're a public record. Okay. So let's talk about just some of the recommended retention periods under the Georgia Records Act. So these are here for your reference, really, and this is not comprehensive. Go back to that if you have questions, and you're going to, because this is not comprehensive. I just kind of cherry picked a couple things just to give you an idea of some of the retention requirements. Go back to that website that I gave you and look for the particular record when you're trying to determine the retention period. Here's one thing, like applications. So if you collect applications and somebody's not hired, you're to retain those for 2 years. Well, it says unsolicited or incomplete applications need to be held only 3 months. This is probably one of those areas where you may say, look, we're just going to retain all applications for 2 years. We're not going to go through and spend the time trying to figure out, well, was this, submitted at a time when we didn't have a vacancy or an advertised position, or is it incomplete? We're just going to retain all of the applications for 2 years. All of the pre-employment assessments, if you do, I know a lot of law enforcement agencies have written testing. Those would be considered pre-employment assessments. All of that needs to be retained for 2 years. Background checks, this includes on applicants that are not hired, and this specifically says criminal and financial, right? And it says the retention period for that is 5 years. Now, if somebody's hired, then that would be subject to retention in the person's personnel file, which is a 7-year post-separation retention period. So drug testing, certain requirements in terms of how long to keep drug testing records, calibrating your drug testing equipment. There are requirements for that. And here's just a list of, other things that might be pertinent to your particular agency. And I don't think I need to go through each of them. I just wanted you to see what the different periods are. And then, employee handbooks, I didn't realize this, but the recommended retention period is 60 years. And I'll tell you, we're currently in some litigation right now where we're having to try to recreate things that happened back in the 70s and 80s. And trust me, you think you're working on antiquated systems now, think about what they were working on back then. And it's, there just isn't that kind of record keeping and access. And even employee handbooks, we've actually been able to recover some of them. But yeah, that's a 60-year period.
So we have a question from Edward Johnson.
Mm-hmm.
He states, we have programs like Citizen Police Academy. What would be the retention on these applications? So a volunteer program of some sort?
Unless there's something, and trust me, I've not memorized what all of the requirements are, what all the categories are. But if there is not something specific to that, I would pick the category that is closest to what you're looking at. So if there's not a specific requirement for, applications for your Citizens Academy, I would probably look at the one for just regular employment applications.
So it'd be the 2 years if they didn't make it, and then if they did make it, for the life plus 7.
Right. Yeah.
Okay.
So, and then personnel files, that's an important one. Those need to be retained 7 years after separation. And so the next couple slides also have, so criminal investigation files, there's for capital offenses like murder, that's 50 years after adjudication. So even after someone has been sitting in jail for, 40, 50 years, you're still required to retain all of the records related to that investigation. So you've got to have systems in place that, number one, make sure that they're retaining that information, but also that it's accessible 50 years from now, right? So that also requires periodic assessment of your systems as technology evolves. And if you are doing electronic storage, making sure that you still have the products in place to be able to access those records. Okay. Another thing, some of you guys may have just on the next slide, Dan. Some of you may have security cameras in your building, and there is a specific, this kind of goes along with the same guidelines as what we talked about earlier with the body cam and dash cam videos, but surveillance video of your building or department, that's 180-day retention. Same thing with holding cell videos, that's 180 days as well. So I would say, you know, anything, unless it falls in that category of events where longer retention is required, I would say most videos, a good retention period across the board, absent something that requires longer, is about 6 months. And this is, I didn't know this either, but under the recommendations from the Georgia Archives, legal advice is supposed to be kept permanently. Now, I didn't know my words were that important, but apparently they are.
So you're saying we need to keep this webinar permanently?
Well, I'm not giving you guys legal advice, right, during the webinar, but yeah, any legal advice that you receive from, you know, your city or county attorneys is supposed to be kept permanent. So that was something that was new to me. All right, so next slide, we're talking about, you know, when do you suspend your record retention periods, right? So you've gone through, you've set out, you know, how long you're going to keep your records. Well, when are you required to suspend those retention periods and retain documents for longer? And that is basically when you need, or you're on notice of pending litigation, either through a lawsuit or an EEOC charge, or maybe there's an ongoing investigation that might wind up in litigation, or you need it for audit purposes. So you would retain those for as long as needed. And that would really be through, at least for litigation and things like that, through the end of the case. Security, I mentioned a little bit earlier, it's so critical to make sure that your information is protected. You know, you guys probably read recently about the ransomware attack on the city of Atlanta, and they were, I think they were requesting, from what I can tell from the records, maybe some of you are more familiar with this than I am, but $51,000, I think, in Bitcoin to get the information back. And it sounds like what the city of Atlanta did was they said, you know, we're not going to pay you, but we're going to pay all of these other firms to try to recover the data and the lost information. And that, at least according to, you know, the newspapers, that cost Atlanta well over $2 million to do that. So if you don't have firewalls and other technology in place to protect those records, I would make that a high priority, because God forbid something happens and your agency gets attacked. And some of the, I mean, I'd say all of you, but especially some of the smaller cities and counties, you know, you're not going to have that kind of money, and nor do we want to spend that kind of money either responding to a ransomware attack directly or indirectly. So, all right. So what do you do about records that are not recovered by the retention schedule? So again, you know, you mentioned that Citizens Academy applications. If there's not something specific to the record that you are inquiring about, just follow the rules of the category with the best fit. So, you know, if it's a personnel record, for example, follow the 7-year post-employment period. If you have any questions at all about, you know, what category a certain document fits into, you can always contact the archives, and I gave you the email address. It's published current on their website, as well as the phone number, and I'm sure they'd be more than happy to help you out. All right, so retaining records electronically. I know some of you all have gone to electronic storage of information just to, cut down on storage costs. And so I just wanted to point out, so you're aware of it, Georgia does have a Uniform Electronic Transactions Act, which is analogous to the federal statute with the same name, minus Georgia. And that really, that addresses electronic records. So it allows you to store records electronically. So it says it applies to any electronic record or electronic signature created, generated, sent, communicated, received, or stored on or after July 1st, 2009. So it allows you to retain records electronically. In other words, you do not have to save the originals if, 2 points, the electronic record accurately reflects the information or the document as it was originally created, and it remains accessible for the required retention period. So if you're just scanning a document, don't just file it without looking at it, right? Make sure that the scan is clear and you can read the document, because I can't tell you, how many times I get documents from clients that's their only copy. They've destroyed the original and they've scanned it, and no one looked at the scanned copy to make sure that it was correctly scanned. So maybe we're missing half the document or it's all blurred. So if you're going to retain electronic records, make sure that you're looking at those once you've got them scanned into an electronic format to make sure that it accurately reflects the information as originally created. And then again, we're talking about, those have to remain accessible for the retention period. So those records that have to be kept for a longer period of time, or even, a few years, technology changes so quickly that, whatever format we retained a record or a video or something in, we might not be able to access that a couple years down the road. So you've got to either retain systems that will enable you to access those records, or you're going to have to transition the records to another format. You can use the services of another person to satisfy the retention requirements. So in other words, you can perhaps provide your records to a third party to store them, whether it be virtually or in a warehouse, for example. And this actually provides that if you retain records electronically and it satisfies those two requirements, this will also satisfy any laws requiring a record to be presented or retained in its original form. So an electronic record will stand in the shoes of a paper record. I will say that the Georgia Archives, we've called them a couple times, and they have recommended that for those types of records that have longer periods, retention periods, to maintain originals. But this particular statute says you don't have to, as long as you're accurately retaining those documents. All right. Just a little bit more about the Electronic Transactions Act. It says that each governmental agency of the state shall determine whether and the extent to which it will create and retain electronic records and convert written records to electronic records. And so that is a mandatory directive, and it says shall, right? So as part of your records retention program, you've got to figure out whether or not you're going to retain electronic records, and you're going to have to retain electronic records if that's their original form. It's just a matter of how are you going to retain them, and then are you going to convert the written records to electronic records? And again, just a couple considerations when doing that. Just make sure that you are migrating records to updated technology if you're not retaining the old technology to access and read the records. And again, should we destroy the originals? As long as you are accurately maintaining an electronic record and you can access it, there's no requirement to retain the originals. All right, so the next slide is federal records retention laws. The point of this slide is just to let you know that there are certain federal statutes that have retention requirements, and I do point out that Georgia's recommended retention periods for most of those are going to be a little bit longer. So if you follow Georgia's retention requirements, you're going to satisfy the federal retention periods. If you have any questions, just make sure that you look into that to confirm. But from what I could tell, as long as you follow Georgia, you would satisfy all of the federal requirements, at least for sort of the primary employment laws. All right, so destroying records, again, it has to be in accordance with your records management policy. You know, is it a good idea to maintain records beyond the applicable retention period? No, because guess what happens? If you get an open records request and you've not deleted files in accordance with your records management system, guess what? Now you've got to recover all of that data and all of those records and produce them in litigation. And so, you know, they might not have any relevance, but now all of a sudden they do have some relevance. And so I would highly recommend that, you know, unless there is a longer period to retain the documents, make sure that you are implementing your program, and so that you are destroying the records in accordance with the program, absent some reason to keep them longer. And if you fail to destroy them, it renders your system useless, and it increases your retrieval cost, and it extends the retrieval time, because the more emails that we have to receive and produce, or the more storage space that we need, that's going to cost your agency money that it doesn't need to spend. All right, we talked a little bit about what happens if you don't comply. We talked about that adverse inference. A court can also impose sanctions or contempt of court if you are directed to produce certain documents and you don't have a reason why you can't. The court can impose sanctions on you. There can also be discovery sanctions, which can be critical to your case. They can wipe out certain defenses of yours, and if you don't have a defense, you basically lose your case. A court may say, well, you know, if you cannot produce certain documents and you can't show that you in good faith deleted records in accordance with your records management program before you were on notice of any pending lawsuit, then you're not going to be able to admit any evidence in support of a certain defense. And so again, that can be highly problematic in litigation. And then a court can also direct you, which is what mandamus relief is. They can order you to take certain actions that are mandated. So those are just a couple of the, and I should mention too, that it's on the next slide, as a matter of fact. Consequences of non-compliance, 5018-102, the highlighted portion, not to scare you, but it does provide that the alienation, alteration, theft, or destruction of records by any person or persons in a manner not authorized by an applicable retention schedule is a misdemeanor. So again, this stresses the importance of having a retention schedule and making sure that you and your employees are following it. All right. So lastly, let's just talk a little bit about defining or designing an effective records management program. And these are just a couple considerations for taking a look at the program that you currently have in place, if you're thinking about updating it or making sure that it's in compliance. You know, define how long, how, and where to store paper and electronic records. Consider all forms of electronic records. That's going to require you to figure out what kind of records you even have. Specify how they're to be destroyed when the retention period has expired. Let's see. I know we're cutting right at time here. Next slide, detail circumstances under which the program should be suspended. We talked about, so lawsuit, EEOC charge, subpoena, Open Records Act request, audit, investigation. If you get an an item notice, that's also notice to you that of potential litigation. Designate your records management officer, and then define penalties. for non-compliance and consistently impose them. So if you've got employees who are not following your records management requirements, implement some type of discipline. Unfortunately, that's the only way we can gain compliance sometimes. Describe the manner of organizing and cataloging your stored records. That way, for those of you who are responsible, who are clerks and things like that, for gathering records in response to open records or litigation or otherwise, can easily find those records as opposed to having to go all throughout your agency figuring out who has records that might be responsive. Include the program in your handbook and have the employees sign when the program is updated. That way, everybody's on notice of what they're required to do and they don't inadvertently delete something that should be retained under records retention. And then more importantly is to train your employees and your staff on records maintenance on your program, and then monitor their adherence. It's one thing to train on it, but if you don't follow up on it, it's not going to be done. So as long as people know what they're supposed to be retaining and identifying those types of records and how they're supposed to be retaining them, you'll be better off all around. And then lastly, when potentially contentious termination occurs or where litigation or EEOC charge is likely, make a forensic image of the employee's hard drive, the network drive, and the assistant's hard drive. And all of those will capture any existing files, any deleted files. And a lot of times I know some of you, once somebody has separated, take their equipment and erase everything and then redistribute it. Well, make sure that you're not deleting records that have to be retained under your retention program. So I would recommend making a forensic image of that hard drive. And then lastly, just back up all your data in case, to make sure that nothing is lost. We have been going through some technology issues ourselves, and so we've had to address, and I'm sure some of you have too, sort of the inadvertent loss of records. And if that happens, I'd rather go back and only lose one day's worth than a month's worth of work. So, so anyway, I hope this was helpful for you. Again, if you have any questions, please feel free to give me a call. I'm happy to assist you or direct you to somebody that can. And, you know, again, if you contact the Georgia Archives, I've always found them to be extremely helpful. And so you might want to start there as well if you have any questions.
First of all, great job, Tracy. I do have one question here. Yeah. Can you tell me where I could get further training for open records pertaining specifically to law enforcement? Do you have any ideas on that?
Well, we could certainly provide you guys some training. Offhand, does LGRMS offer?
No, we don't really. But what I would suggest you do is, if you have questions, I'm going to shoot your email with that. So you can just shoot them to you, and we'll try and find that. Well, if you have more specifics, what you're looking for, definitely shoot it to us, and we'll try and find that and shoot it to you. But great job. Everybody clap. Great job. Actually, I thought it was fantastic. So you guys have a great day. I will send you a link with this recording and with the presentation and with some programs and policies. Shoot me any of your other questions out there. Thank you guys so much. Have a great rest of the week.
Yeah, and then Dan, my contact information too is on that very last page.
And I'll send you that contact information. Thank you so much.
All right. Take care.